Welcome to this edition of Real World Business. I'm Seth Berenzweig, managing partner of Berenzweig Leonard, here in our beautiful brand new broadcast studio here in Tysons, Virginia, here with my colleague Kristin Zech. Kristin, how you doing today?
Pretty good. Seth, how are you?
Doing great, doing great. Well, we're here today to talk about an evolving issue and something that's really very important, although it's also based upon really unfortunate circumstances. We know that we are seeing tragically every day the business impact with regard to Russia's invasion of Ukraine. And there are the immediate top-line effects that we're familiar with and that we see every day in terms of increased food prices, increased gas prices, increased energy prices. But what we're going to talk about today is going to be an issue that's bubbling up underneath the surface. And it's a question of whether the Russian invasion is going to have a potential impact on business contracts here in the United States. And these are things that unfortunately are going to continue to be coming out more in the forefront. So we're going to be talking about contract principles today that could impact your business contracts. And Kristin, let's go through some of the fundamental theories of business contracts as it relates to this issue. And let's start with an issue and a topic called force majeure. You know, we've heard so much about that, and it's being covered a bit superficially in the media, but can you explain what is meant by force majeure and what, if any, impact it's going to have with regard to this issue?
Certainly. So when you have two parties or more that come together, the whole idea of a contract is that we've defined what everybody's responsibilities are. A force majeure clause allows the parties to allocate responsibility and risk in the case of certain events. And usually those events are enumerated: acts of war, governmental actions, terrorism, things like that, where there are defined criteria, defined events that then the parties are able to say, if this occurs, then either my performance is delayed while this is pending, or in some cases, if it goes on long enough, my performance under the contract and the contract itself can be terminated.
So literally, an act of war could constitute a so-called force majeure that could have an impact on a business contract. Is that right?
That's correct, but we need to be very careful because the force majeure depends specifically upon the language that's in that clause.
Right.
And it's critical that you go back to your contract and see exactly what acts are covered and which are not, as well as what the consequences are. We saw this, for example, with the pandemic, because the pandemic in many cases was not covered under a force majeure.
And in fact, one of the things that you're pointing out is that the only way that a business can really have a clear, immediate understanding of what, if any, relevance this has is to actually go back and pull up the contract language, right?
It's key, and it's so simple, but it is critical. The very first thing you need to do is go back and look at your contract.
Right, right. And this is something that can have an impact from both an offensive and a defensive perspective, right? In other words, we're not just talking about an instance where someone who's having a problem with regard to critical supply chain issues, significant delay issues, things that could be occurring as a result of the war, looking at it from an offensive perspective to trigger a force majeure to see if there's enough of a leading out of the gray area to get out. But it's also something that someone needs to be aware of in terms of an incoming issue from that standpoint. Is that right?
Absolutely. Anytime there's a concern, you should go back and look at that contract and see how it may be used either to your benefit or may be used against you.
So let's talk about two related but distinct concepts that are known as impossibility and frustration of performance. That's something that's very much also a very top-line and well-known contract issue that could be bubbling around the surface. Talk to us about that a bit.
Certainly, and I want to add in a third component to that, that's also impracticability. When we have a situation where the force majeure clause is not going to address our circumstances, or we look outside, or there is no force majeure clause, we look outside of that clause into various common law principles. That involves impossibility, commercial impracticability, as well as frustration of purpose. Each of these are very distinct principles and very difficult in many cases to prove.
So again, let's talk about it in a real life notion. If we have a situation where we don't have a force majeure clause, where we don't have something that includes like an act of war or something that could excuse or terminate performance, but there may be general legal implications in the background that relate to the work that I'm doing. Let's say I'm a company in Tyson's and I have to deliver products and services, but the supply chain is creating a new problem. I have huge delays. I have completely dramatically increased costs. I've bid the work to the federal government based upon certain cost assumptions. Explain to me in real life terms how something like that might come into play for companies.
Sure. When we look at those three principles, each of them may play out differently. And again, this is going to be a very, very fact-specific inquiry in terms of how this will ultimately result for the company. If we look at impossibility, what we mean by that is it is truly impossible to perform. What I was trying to do, I no longer can. The classic example here is I've hired you to put a roof on a house. Before you put the roof on the house burns down. There is absolutely no way that you can put the roof on that house. That becomes an example of impossibility. When we look at commercial impracticability, that really is the question of, has this cost been escalated so high that it is objectively unreasonable for me to be able to execute on this contract? I think that's probably where the biggest concern is going to be when we start looking at supply chain issues. Because if we're no longer able to, or if a company is no longer able to get the materials they need at an appropriate cost coming from Asia or coming from Europe, or if the port at Odessa is closed, at what point do the economics just not make sense?
See, I can see this coming into play, for example, and again, everything that we're talking about foots back to the actual day-to-day market of what our clients are dealing with. Let's say you're a prime contractor and then you are teaming with 3 subs and you're delivering goods and services to the Department of Agriculture. If 1 or 2 of your subs is having significant increased costs and delays with respect to things that are deliverables under the contract, then that may put you, the prime, at risk, because these are some concepts that may be coming into play that you as the prime may not even be aware of, but that you need to be aware of in the background. So it would seem to me that one of the first tips that I picked up from what you said in terms of force majeure is look at your contract. But the second point that I'm picking up in terms of aspects like frustration of purpose and things of that nature is to stay posted with your teaming partners. Because if there are delays that are coming down, you want to make sure that you're very proactive in managing those, because if not, if you're not aware of these contract principles, is it something that could ultimately be a big problem?
Absolutely. I mean, when we look at impracticability, again, just mere increase in cost is not going to be enough. We need something that is to be so excessive that it becomes unreasonable. So if companies are looking at any of these 3 principles and seeing this as the get out of jail card free, that's just not how it's going to play out.
Right, and also to be aware of how to be able to respond to that if and when that comes up from any of your business partners. Another concept that I'd like to bring up, which is also a very well recognized principle under contracts, is the concept of illegality. And the reason why this is potentially now coming into play is because the White House has issued various sanctions, and there are sanctioned companies, individuals, that relates to oligarchs, that relates to certain financial institutions. Talk to us a little bit about how does illegality come into play and how is that relevant to the bottom line in terms of these kinds of contracts?
It's something that a company that is doing business, particularly in Russia, but potentially in most of Europe, should be aware of as this evolves. At this point, it is an evolving situation. It's not a broad-based restriction on all business at this point, but we don't know what's going to come up. And it's something that, again, any company that is working in this area of the world should be on top of this before going forward. So
one of the things that I find interesting about the way that you're addressing this is that you're really kind of highlighting things that that executives that are watching this can really take back to think about and put in their toolbox for each of these points. And when I'm hearing you talk about illegality, it kind of reminds me of, in the banking venue, the law of know your customer. And it kind of rings a bell in the back of one's head as to know your business partner. Sometimes we don't really know in depth who we're doing business with. You may have a pretty good idea, but what, if any, practical tips are coming up in this realm in terms of partnering with with companies here or abroad that businesses can be careful of to try to be aware of this kind of issue?
I think, again, it's important to stay on top of the news that's coming out and on top of the restrictions. If you have interests in Russia in particular, you should be addressing those already.
Or if perhaps your business partners do.
Or perhaps your business partners do.
Right.
That may affect your employment or the employment of your business partners in terms of whether there's individuals who are in Russia, whether they have employees who are in Ukraine.
Right.
So you should be aware of that so that you can plan accordingly.
And one of the things that you're also driving home is an interesting observation that the president is going to Brussels this week to meet with NATO leaders, and there are probably going to be additional messages, additional conclusions that are coming out of further meetings with Western Europe that might have a direct impact on this issue. So it's not something that you need to be aware of in terms of knowing your business partners, but to also be aware of what executive orders are coming out from Washington and NATO, because that might also have an impact. Just to kind of bring this topic home, let's talk about other practicalities that may not be purely legal. And what I mean by that is, are there any issues that companies need to be aware of when they're doing business in terms of optics? And what I mean by that is, sanctions tend to be specific. They can be company specific or a politician or oligarch specific. It may not necessarily be an instance that a company like McDonald's was absolutely required to withdraw from Russia, but they did it for a certain reason. What, if anything, do business leaders and executives need to be aware of as it relates to the current armed conflict in the business perspective with respect to optics?
I think your point is spot on right now. Even though companies have not been required to leave Russia, they are, and we're seeing a domino effect. And for example, if we look at Subway, Subway does not actually do corporate business in Russia. And yet in the court of public opinion right now, Subway is facing a lot of pressure because their franchisees, over whom they really have no control, are continuing to operate. So even though the company itself is not actually engaging in business, it's feeling the repercussions of having a tie to Russia.
Well, there's the old saying of when you lose your reputation, where do you go to find it? And when you're talking about some companies, there are companies that have decided, at least at the moment, like Papa John's, that they don't want to get out. There are other American companies like Burger King that, like McDonald's, have decided that they do want to get out, but they have partner agreements with Russian businesses where the terms don't make it practical for them to be able to immediately cease operations. So that goes back and brings us full circle to the point that you raised at the outset, which is know your contracts and know your business partners, right?
Absolutely.
Yeah. Well, thank you so much. This will be an evolving topic, and it was a great discussion, so thanks for joining us today.
Thank you, Seth.